Welcome everybody to our webinar this morning. This is for tenant selection and tenant termination. And I'm Steve Tom Koviak from the Fair Housing Center, Metropolitan Detroit. Thanks to see everybody, so to speak, today. Thanks for coming out. Question is, if we take this example here, an applicant, black male, has a 15-year-old conviction for felonious assault, that's felony, or assaultive felony, served 15 months in a state prison, been released, has not had any other criminal record since that time. Other factors pertaining to his qualifications, income, rental history, credit, are all fine, other than the criminal record. What's your decision? Is that sufficient? Are there other factors that you would need to consider? So we're going to look at what kind of policies can and probably should be adopted so that housing is inclusive and open, available to all who merit being a tenant. Here's an actual phone call.
Yes, again. I just was wondering if there was really nothing. I really wanted to stay there.
No, I understand. Well, I appreciate you calling. Unfortunately, once we know, we can't unknow. And that's the part where we can get legally in trouble, is if we make special favors in the event that, you know, if we were to accept another person or deny another person, we would now be considered inconsistent. And that is where we have problems with the law.
So, I mean, like, you guys can't send it like to your legal department because I have a criminal record? I mean, just having a blanket policy, I mean, there's nothing that can be done?
So that's what the thing is that we can't use discretion. Fair housing puts a line in the sand. And that way, no one gets discriminated against or a special favor because of anything particular. So we equally have to basically say yes and no.
Mm-hmm.
We can't start weighing things at all. We have to have a strong line in the sand, and that's how real estate works. I know that when someone has a different kind of business and offering discounts to people, et cetera, it's totally different. But fair housing, this is law. This is really, I mean, I'm even surprised with some other businesses how lenient they can be on renting equipment, et cetera. You know, renting houses. Housing is the most sensitive topic of humanity.
Yeah, I get it. You know, and because it was a long time ago, and I have been working since then. That's the only time I've been.
I know. I'm sorry. That's not something that we're allowed to use discretion with whatsoever. It has to be
public.
It has to be very firm and very strict. Otherwise, you know, imagine all the people that we've said no to in the past that could come back at us in the event that they were to, you know, hey, I know that guy. I have a record like him, and they told me no over there. What's he doing living here? How come I got to? And then
so it's either misdemeanors and felonies, or just felonies?
Criminal history, anything that comes up on the report. So if somebody stole from Kmart, you know, 5 years ago.
Mm-hmm. Okay.
Kmart was more than 5 years ago.
Well, yeah, I know, right? So you said I would get my application feedback?
Yes, I did actually. I refunded it for you. And because it is digital, it'll take that 5 to 10 business days, like when a retail store is refunding you your application fee.
Okay.
And like I said, it didn't pull hard on your credit, so it didn't affect your credit score. And at least now you know that, you know,
the credit score was okay though, right?
Yep, your credit score was approved.
So the credit score was good. Everything was good except the background.
Thanks to Misha again for sponsoring this webinar and other webinars. Without Misha, this would not be possible. Key resources and guidance and identifying the reason or why there's a heightened concern now with overbroad criminal record policies. We're going to look at fair housing, liability that can arise for overbroad policies as to criminal records. And then we're going to focus on a real key question. What's a reasonable look back period? That's a really question people ask all the time. How many years back can or should you look? Then we're going to go through some sample policies. The key thing here is the policies govern both admission and termination of occupancy. Quite a few housing providers have admission policies in terms of criminal record, but they don't have anything in terms of when occupancy or rental, whatever, can be terminated because of criminal activity that occurs after somebody moves in. And then there's going to be just some recommendations and checkpoints that you probably want to consider when you're looking at your criminal record policy and reasons for the heightened concern that exists today with overbroad criminal record policies. So the key resources that you should consider, and you'll see it kind of, these are referenced below, is there's a notice of proposed rulemaking. It hasn't become a final rule. It just came out in April. Those are reducing barriers to HUD-assisted housing, basically public housing, reduce barriers to people with a criminal record. There's also, which a lot of people are aware of, HUD's Office of General Counsel, or OGC, came up with guidance in April 2016 on application of the Fair Housing Act, standards to the use of criminal records by providers of housing and real estate related transactions. Then in 2022, in June, HUD, Fair Housing Equal Opportunity Office, issued kind of guidance, again, implementation of the OGC April 2016 guidance that gave some helpful information as well. And then there's a prior HUD notice for public and Indian housing guidance for public assisted agencies and owners of federally assisted housing on excluding the use of arrest records in housing decisions. That's the main guidance. Other guidance in that we have picked up key court cases, and those will be referenced. If anything comes up, you'll have the source there to look at, and you'll be able to check further. So question here is, why the problem? Well, actually, there's disparities. The U.S. first, we have a heavy prison population in the United States. So the U.S. population is less than 5% of the world's population. It actually has over 20% of the world's prisoners. It's an incredible amount, by between 770 and 100 million, or as many as 1 in 3 have some type of criminal record. By 2021, as of nearly 445,000 people released from prison. Individuals in prison and jail are disproportionately poor compared to the overall U.S. population. And the disparities are this: Black Americans are 38% of the incarcerated population, despite only being 12% of the U.S. population. And if you drill down further in Black male population, they're nearly incarcerated 6 times the rate of white men. Black men with disparities are 2% of the U.S. population, but yet 18% of the state prison population. Hispanic men, same kind or similar disparities, incarcerated nearly 2.5 times the rate of white members of the population. And there's also disparities when it comes to Native Americans. So just if you take the prison population or people with criminal record, they're disproportionate, just a fact. And there's a connection between the criminal justice system and homelessness. Those who have been incarcerated are 7 times more likely to have experienced homelessness. If they've been arrested more than once, that rises to 13 times more likely. One study estimates the sheltered homeless rate is 98 per 100,000 for formerly incarcerated individuals, compared to just 13 per 10,000 for the general public. You can see, right, homelessness is going to really hit on people that have a criminal record. Unsheltered homeless rate, 105 per 10,000 for formerly incarcerated individuals, just 8 per 10,000 in the general public. Additionally, 37 per 10,000 formerly incarcerated individuals have marginal housing insecurities, are living in rooming houses and so forth, motels. The average person experiencing chronic homelessness can cost taxpayers between $30,000 and $100,000 per year. Homelessness comes with a very, very high cost. So those are concerns. And what's the concern that people have in renting to someone with a criminal record? Well, recidivism. They're going to commit more criminal activity. Studies show that a person with a prior criminal conviction, if they haven't committed another offense within 4 to 7 years, they're no more likely to be arrested for a crime than the person in the general population. Spending over the life course shows that most crime commissions occur and peaks in mid-20s. Actually, with males, their brain fully develops at 26. Studies recognize that. And it drops as a person ages. People no longer commit crimes by their 40s. and desistance from crime overall is the typical outcome. I'm always a comment to my son, like, you don't see 80-year-olds breaking traffic laws for the most part, right? Life has a way of making you do the right thing because you just get tired of consequences. So it is with all kinds of activity. Realize, hey, why don't I just go about things the right way, the easiest way, and conform a little bit, much as you may not want to. Lightweight, but when it comes to criminal activity, people tend, once they start working and getting regular income like that, and they're housed, they tend to then the criminal activity drops off substantially, if not all the way. Although if there's a negative part, over 70% of state prisoners who released from prison were arrested with 5 years following release, but half of these arrests were for minor offenses, public disorder type offenses, right? Nearly all of those offenses will fall into the category of non-criminal technical violations. But here's the key factor. The evidence is pretty strong that stable housing and housing assistance programs reduce recidivism across the board. That's the key factor. So how likely are someone to be a successful tenant, right? Persons that experience homelessness on average having criminal history made no difference in the ability to successfully stay housed. There was a long national study of 15,000 veterans who were transitioned from homelessness to housing, found that incarceration did not impede connection to services or success in obtaining or maintaining housing. And you can see, again, the research shows that over time, criminal conduct will decrease. It absolutely does. Study of relationship between criminal conviction history and housing outcomes among 10,000 households found that 11 out of 15 conviction types in resident criminal history show no evidence of impact on negative housing outcomes. The remaining 4 types, property offenses, major drug offenses, fraud, and assault, did show impact on negative housing outcomes, but even they increased the probability only 3 to 9 percentage points, and even that decreased over time. So if you look at that NPR on reducing barriers, that can give you some guidance as to what you would consider to be, or what you office would like to be considered to be disqualifying type of criminal conduct or prior criminal conduct, as to what you would consider to be more minor. Proposed policy below will kind of list some of those things as well. Blanket criminal record policies will be a problem. And if someone has an overbroad or a blanket exclusion, the problem you'll face is you got to have empirical justification as to why you have a per se disqualification without taking into consideration other evidence or mitigating information bearing on someone's fitness for tenancies. There have been studies of testers, some with criminal histories and some with not. They found significant differences in success in housing admission, meaning people are getting screened out by criminal record at the application stage. Even though there's not a lot of empirical basis, housing providers are continuing to deny people housing based on people solely or largely on their criminal histories. One study found prospective tenants without criminal records were more than twice as likely to have cause return, 96%. Those with criminal records, only 43%. So what are the common landlord practices? This is from the Yim case out of Seattle. About 90% of the private landlords conduct criminal background checks. Nearly half of the private landlords in Seattle, said they would reject an applicant with a criminal history. And then there's something to it, kind of as many fair housing issues do. It's often mass race discrimination. They can use it as a way to screen out non-white applicants or non-white tenants by basing the policy on someone's criminal history. And you can see the bottom report, 2014 report found that testers belonging to minority groups were frequently asked about their criminal history, while similarly situated white testers were not. The difference at 64% of the time. Isn't that amazing? So the result, racialized discrimination leads to homelessness, or is a factor leading to homelessness. It also impacts families. Many number of children of a parent with criminal record means the impacts of overbroad criminal record policies will hit children and multiple generations. It can make family reunification in a post-incarceration life for the individual very difficult, and can result in children being placed in foster care. What is fair housing liability for overbroad policies? not going to go into a ton of it. I will reference the cases in that later on. But really, it started with the HUD 2016 Office of General Counsel guidance. And the key thing is that housing provider, whatever policy is adopted, must be necessary to achieve substantial legitimate non-discriminatory interest. That's really getting at a disparate impact analysis. If it's a policy to exclude all persons with prior convictions, won't satisfy that requirement. It means if there's a blanket prohibition without any consideration of when the conviction occurred, the underlying conduct, what the person has done since that time, they're unable to meet the burden of establishing that that's necessary to achieve their substantial legitimate non-discriminatory interest. We're assuming that that interest is safety to the owner, management company, staff, other tenants, and not having damage to the property. It's all safety issues, the main concern. But again, a blanket policy is not necessary to meet that safety goal. It wants something more particularized. HUD's Office of General Counsel relied on Title VII employment cases where there are blanket bans on hiring people with a criminal record. The quote is pretty good. Could not conceive of any business necessity that would automatically place every individual convicted of any offense except minor traffic offense in the permanent ranks of the unemployed or the unhoused. And whatever if a employer adopts that kind of a policy, they have to show that it has been empirically justified, which is not likely. And even with a more tailored policy that excludes only certain types of convictions, the housing provider must still show that the policy is necessary to serve their substantial, legitimate, non-discriminatory safety interests. The bottom line, that whatever policy is adopted must distinguish between criminal conduct showing a risk to resident safety and or property, as opposed to criminal activity that does not. Now, there are a couple exceptions or exemptions from fair housing coverage. If someone has been convicted of the illegal manufacturing or distribution of a controlled substance, they're not protected. And the caution is that it must be an actual conviction, not merely an arrest, and they must conduct individualized review for other drug-related convictions, such as drug possession. I want to do a kind of a clarification on the actual conviction, not merely an arrest, meaning if the arrest was in years past, there's no clear indicator that the prosecutor or DA, whatever, is moving forward with the charge, it should not be considered. That's a mere arrest. But for example, if someone gets arrested last week for felonious assault or attempted murder, something major, you have to, you don't base it alone on the arrest. You have to look at the circumstances surrounding that arrest based on whatever information is available and then consider it. Now, I will caution, right, there's Ann Arbor by ordinance does not allow even an arrest to be considered. HUD's view, and I think the better view, is that you can consider arrest provided it is a current situation in which the prosecution is proceeding or will proceed. Then you can consider it, but you've got to dig out and get the facts for it. We had a complaint like that, and we had the complainant give us all, basically the police records, the witness statements and that, so we could make a determination as to whether to proceed with a claim of a criminal violation as to criminal record. So it's case by case. But if it is an old one, and that's in the 2016 OGC guidance, and it's not being pursued further, absolutely, you do not consider that arrest. Again, don't automatically consider an arrest. But don't automatically exclude it either. If you're in Arbor or ban the box type of an ordinance. Yeah, there are two, when it comes to public housing, two statutory required exclusions for federally assisted housing. The persons who are lifetime required to register as lifetime sex offenders, and those that have been convicted producing methamphetamine federally assisted property. Other than those two, public housing authorities and HUD-assisted housing owners are not required by statute to deny housing assistance to people with prior criminal convictions. Now, there's two qualified, these are not absolute public housing exclusions. They have to prohibit admission for 3 years from the day of the eviction if household member has been evicted from federally assisted housing for drug-related criminal activity. Again, they also may admit the individual if they determine that the person has successfully completed a drug rehabilitation program or the circumstances that led to the eviction no longer exists. They must prohibit admission of households with a member who the PHA determines is currently engaging in legal use of a drug, or determines as reasonable cause to believe a member of the household, the legal drug use, pattern of legal drug use, alcohol, and so forth, may threaten the health, safety, and right to peaceful enjoyment of the premises by other residents. It says must, but again, these are not absolute, so that's a yellow flag or a yellow indicator there that it can be cautioned, and I mean, you can allow it, but there has to be clear circumstances showing why this would not exclude an individual. Those with criminal records, the 2022 implementation points this out. They may also be covered when we talk about someone being turned down housing or evicted, mainly turned down on the application stage, that it can have a disparate impact based on race, Black individuals, or Hispanic. Yes, it's going to have an overbroad policy will have can have a disparate impact, but there's also, it can violate disability protections because the definition of disability includes alcoholics, former not current drug users, as well as persons with other disabilities. Often these individuals have a criminal record. It's unlawful to be discriminated against based on disability, for example, denied housing. There's also can be a reasonable accommodation claim because many alcoholics, former drug users have criminal records. Because of their prior drug addiction or drug use, they're going to have probably poor rental histories, low credit scores because it disrupts employment and so forth. And that warrants the need for reasonable accommodation requests. And then also fair housing claims involving use of criminal records can be based on denial of reasonable accommodation requests. We had exactly that kind of a case because there were 70, 80 people who were evicted. They were in a drug treatment program. The entity that provided the therapy and the counseling, intensive drug rehabilitation program, both for alcoholics and former drug users, they had a program where the entity was the tenant, and the tenant would place the people in the program into housing. In 2-bedroom units, they would place 4 men or women. In 3-bedroom units, they would place 3-bedroom units, they place 6 men or 6 women basically in order to continue with the intensive treatment that people were receiving. It's a very successful program. It worked really, really well. Who was the tenant? Actually, it was the entity, right, that provided the counseling and drug treatment program. The people in the program were just occupants in the units. And they had a 15-year track record of never missing a payment. If there's any kind of problem with the conduct of people in the program in the apartment complex, they would transfer the persons to a different facility or a different apartment complex. So they had no problem. They had no problem with the people that were in the program, and the rent was paid consistent within 15 years. A new owner or management company came in and said, well, we want a different demographic, but it was that kind of a statement made. And so they started to issue non-renewal notices, basically evicting between 70 and 80 people. Then around that time, the administrative individual for the treatment program provider got an email from that same housing provider and said, here's an opportunity to come in and rent you 13th month free. So they contacted, find out that they did have units available. At the same time, they were evicting people going through the drug treatment program. That's disability discrimination straight up. So they were scrambling to get their individuals placed into other apartment complexes. One apartment complex said, well, we have a 600 credit score requirement. I'm sorry, the people in your program, and they said, well, we can't, people in our program don't meet that requirement. They don't have 600 credit scores. And the reasonable accommodation request was to ask for an exception to the 600 credit score requirement because the people coming out of that program didn't have it. And the more important part is who is the actual tenant? It's the drug treatment, services provider, and they're actually the one that were the tenant. And there's no question about their ability to pay and pay in time. And so at that point, the housing apartment complex agreed to waive the 600 credit score requirement as a reasonable accommodation. Had they didn't, that certainly would have been a violation. Now, in terms of court cases, I'm not going to go through those here, but the NPR on reducing barriers to people with criminal records, It's 89 Federal Register at page 25, 346, summarizes the leading court decisions in which housing providers have been found liable under Fair Housing Act because they have overbroad criminal record policies. So that summarizes those. I really want to focus on the key things in what policy can or should someone adopt? What should the standard be? So the key question here is, what's a reasonable look back period? How far back can or should you go? HUD in the notice of proposed rulemaking came up, and it's proposed, it's not finalized. It came up with a look back period of over 3 years is presumptively unreasonable. Now, it does acknowledge that public housing authorities or owners could determine a longer look back period for certain crimes if they're able to provide empirical evidence justifying a longer period. That is a change from HUD's policy in 2001, over 20 years ago. They had 5 years as a reasonable period, look back period for serious offenses, depending on the nature of the offense. But looking at what's being adopted throughout the country, District of Columbia, 7-year look back, Colorado, that was 2018. You can see the trend where it's getting lower. Colorado, 5 years, Illinois, 6 months in 2021. New Jersey, 6 years for first degree indictable offenses, 4 years for second or third degree indictable offense. So it's kind of a sliding scale. Same thing with New York Housing Agency, 5 years for felonies and 1 year for misdemeanors. Seattle, Oakland, Berkeley, Ann Arbor prohibit inquiring as to criminal record history. So there, they don't even have to answer that look back period. So again, HUD's recommendation is 3 years. It's the best we can do by way of guidance right now. I'll go with the 3 years, as following HUD's leadership as kind of a balance between the various approaches of the states and municipalities. So what would be good sample criminal record policies? First, there has to be one for admission and then a policy governing termination of occupancy. Here is in the 2015 Public and Indian Housing Notice at pages 5 and 6. It says, you can see Part B, some PHAs have adopted look back periods and so forth. One PHA adopted a 12-month look back period and 24 months. You can see even then, that was back in 2015, there was a PHA that adopted a very short look back period. But what I think is Part C is really good. Again, HUD recommends it. The 2016 Office of General Counsel guidance cites this as a sample of a good best practice. So we'll go with this. And then this is again at the initial screening for a criminal record. So Part C, factors that you look at, not a blanket ban, but factors that you look at, whether the prior offense bears relationship to safety and security of other residents, the level of violence, if any, of the offense for which the applicant was convicted, the length of time since the conviction, the number of convictions that appear on a person's criminal history, and if they're in recovery for an addiction, whether they're under influence of alcohol or drugs at the time of the offense, and any rehabilitation or like mitigation efforts that the applicant has undertaken since the time of the conviction. So that's pretty helpful. That's a pretty good guidance. Again, it sounds like, well, it's not real hard and fast. Exactly. It's to make sure you really take a look at the individual and their background and their criminal record and what occurred since the criminal history occurred, and what steps and how are they going on with their life, and just practically speaking, do you think that person presents a real threat or not? If the answer is no, not really, then you don't do it, right? On the video clip we started at the beginning, shoplifting from Kmart 5 years ago, if Kmart's still around, shoplifting from Walmart 5 years ago, that's not an offense. That's not a real concern, right? And so it's the opposite. On that recording, everything she said was actually wrong. It's not a hard line in the sand. It's a case by case considering the situation involving with the applicant. Here's another example. This is drawn Detroit's fair chance access to rental housing, just an example of a local ordinance. And again, you'll see here, this has been passed a couple years ago, probably no longer giving the guidance, or it's not as, how would I put it, inclusive as probably it needs to be. But the first one is conviction where state or federal law prohibits the applicant from being eligible for public housing. Detroit says you can adopt public housing standards for your policy. Again, Detroit's not dictating the policy, but giving some parameters as to what the policy should or shouldn't include. Any conviction that leads to the applicant becoming a lifetime registered sex offender, that's pretty clear. Any conviction for violent or drug-related felonies, that's actually way overbroad because it doesn't even have any time limit on it. Someone could be a felonious assault or attempted murder, but that could occur when? 1980? And after, 44 years, convictions for felonies committed within the last 10 years, or imprisonment for felonies within the last 5 years, that's probably needs to adjust in terms of the look back period. Convictions for crimes against landlords, management agents, their employees or agents or other tenants or real property. Again, you want to subject to a reasonable look back period. Any conviction or plea to crime involving arson. Arson would be a good one to look at, as well as metal theft, vandalizing, or otherwise damaging real property. So 5, 6, and 7 are pretty good guidance because that relates directly to what a housing provider, the concerns that a housing provider would have in rental property or, co-op, condo, those types of housing. And so, yes, that actually connects up with housing very, very well. So again, Detroit was good at the time, now needs to be adjusted. Hopefully Detroit will do so. And clear too, though, I'll say at the end, right, just because Detroit ordinance has it specified that way, people are still subject to overriding federal fair housing requirements in terms of their criminal records policies. So another key factor is, well, what would be an example of best practices for terminating occupancy? Again, this is from the 2015 PIH notice. And here's factors that they look at, A through H: seriousness of the offending action, especially as to how it would affect other residents, the extent that the leaseholder, or could be condo owner, co-op shareholder, participated, said that they participated in it, or other household members participate in offending action, including whether the culpable member is a minor, a person with disabilities, or victim of domestic violence, dating violence, sexual assault, or stalking. We had one where they're seeking to terminate a grandmother because 2 of her granddaughters got into a confrontation with some other high school girls in the parking lot. The grandmother knew nothing about it. They were moving to evict her. And so we were able to save her tenancy by just negotiating that, if she was going to meet with the daughters, she'd meet with them elsewhere and they would not be around, and therefore she should stay. The guidelines actually said that they may evict, not that they shall evict. So there is a lot of discretion. And so the grandmother was able to stay. So you have to look at it. Was she the culpable member? No. Was she participating in it? No indication of that at all. So she really shouldn't be evicted for that. C, the effects that the eviction will have on other family members who are not involved in the action or failure to act, the effect on the community of the termination or the PHA's failure to terminate the tenancy, the effect on the decision of the integrity of the public housing program, the demand for housing by eligible families who will adhere to lease responsibilities, the extent to which the leaseholder has shown personal responsibilities or they've taken all steps to prevent or mitigate the offending action, length of time since a violation occurred, family's recent history, and the likelihood of favorable conduct in the future. So recommended, HUD's 2016 Office of General Counsel guidance recommends this as an example of a good best practices for terminating occupancy. I took from the current 2024 Notice of Proposed Rule on Reducing Barriers, as well as a conciliation agreement in Zuniga versus Residential Management. And there's another one, Housing Opportunities Made Equal, or Home of Virginia, taking these and came up with a sample criminal record policy. I'll put the Word version again in the description so you'll be able to access it. So sample criminal record policy, and right at the onset, providers committed upholding fair housing principles and assuring equal housing opportunities. The property will not apply a blanket ban. That's important to point out. And here's the standard for the criminal background screening. The property will conduct criminal background screening, individuals 18 and older. However, property only consider felony convictions that fit within the following 5 categories: property offenses, and you can see it defined in the footnote, major drug offenses, fraud offenses, major violent offenses against persons, and sex offenses. The property may consider felony convictions for violent crimes against persons, sex offenders, major, so forth, that occur within a reasonable time prior to the date of application. Application may be denied for persons who are subject to lifetime registration. Also, applications may deny for persons who are currently illegal users of drugs, or pattern of illegal drug use or alcohol abuse may interfere with the health, safety, right to peaceful enjoyment by other residents. And in making this determination as to current illegal use or alcoholism, to the extent it interferes with health, safety, or right to peaceful enjoyment by others, restrict consideration to just 12 months. And any such determined based on the preponderance of the evidence, more likely than not, and will also take into account any mitigating information. Any other category of offense will not be considered. Criminal screening will not consider charges, expunged convictions, convictions reversed on appeal, vacated convictions, and so forth. An arrest record alone, right? You can't base it alone on the arrest record. The actions that result in the arrest may be considered, but there has to be sufficient evidence independent of the arrest that the actions occurred. Property will not treat people differently because the applicant is on probation or parole. Now, here's the assessment. If they have a criminal felony conviction, one of the specified offenses, the property will then, doesn't say exclude, says they will conduct an individualized assessment considering the following factors. And you can see these factors that are listed here. So you can see all the factors we mentioned, pretty good guidance on that. I'm not going to read it. You'll be able to, see it. And then the property will assess the applicant or tenant based on all available information, including information received from credit and criminal background screening provider, and can be supplemented by any information provided by the applicant or tenant. And then, again, it's the factors to determine whether a tenant is able to fulfill the obligation of tenancy and not create a heightened risk to safety of the community where the property is located. Failure to disclose, right? They can deny occupancy or tenancy or admission only if the criminal record would be material to the admissions decision. Then there should be a policy for terminating the tenancy. Any termination based on criminal activity, illegal drug use, and so forth must be in accordance with the procedure and requirements as set forth in this policy. So the property may require a tenant or applicant to exclude a household member from residing in or continue to reside in the unit if it's determined that a household member has been participated or culpable based on a preponderance of the evidence for failure to act that warrants action or failure to act that results in denial. That's kind of the standard for terminating tenancy. You can add more detail to that if you like. I like the factors in the PH notice as well. This is a little bit more. Factors are actually listed previously that can be considered. Let me go back there. For terminated tenancy, I think you would use the same assessment factors right here. And I added here for assessment, if you see on the second sentence, the assessment will consider the following factors in determining whether to approve or reject the application or to terminate tenancy. So use these same factors both at the decision to approve someone for tenancy or to terminate tenancy. And then going back to termination, shall not expend that the period that any of it could be denied admission for that action, considering all relevant circumstances. Then reasonable accommodations. The policy agrees to comply with the obligation to consider and provide reasonable accommodations of persons with disabilities. Reasonable accommodation may include, for example, disregarding the conduct or record if it's disability related. And then the notice, if some property decides to reject an applicant or terminate the tenancy, they will notify the applicant in writing of the decision and the reason for the decision. The notice gives the applicant 15 days to dispute the findings and provide additional information for the property to consider as part of the individualized assessment. I put the 15-day period because that's what Heightened, the proposed rulemaking, is setting that forward for public housing. You don't necessarily have to use that when it comes to private housing. When it comes to public housing, there's a due process right where someone gets notice, an opportunity to be heard. So that's required when it comes to public housing, not required when it comes to private housing. It's still not a bad information, but I'm not sure many housing providers are willing to wait 15 days to get information back from a prospective tenant. They want to fill that unit much faster than that. That's your call on that one. At the bottom here, it lists certain kinds of mitigating information that could be provided. Confidentiality. The property agrees to keep all records and information obtained as part of this criminal screening policy strictly confidential. And the property also will disclose its criminal screening policy to all applicants in the application or materials attached thereto. I think, to me, that is a big deal that criminal record policy or screening policy be provided. in many of the situations where we receive complaints or we're investigating criminal record policies, it's kind of a back and forth thing. When we go to the housing provider will say, oh, it's a third-party screening company that makes the standards and makes the call. And then we had one where the tester then followed up, it's a recorded call with the third party, and the third party screening company said, oh, no, we base that on the criteria of the housing provider. The reality of it is most of them, the third parties may have various screening criteria. They'll provide options would be maybe the way to put it. They provide that to the housing provider, and the housing provider then selects what would be disqualifying factors or incidents in the criminal record that would result in a disqualification decision. Probably it's coming more from the housing provider, though they make it seem like it's coming from the third-party screening company. And again, regardless, not if it triggers or something is triggered that there is a possible something disqualifying on the criminal record, there still should be an individualized determination, talk to the person, see if there's mitigating or additional information that can be used to see if it's possible that the person could be qualified for rental. So what are the sources for this? Obviously, the Notice of Proposed Rulemaking, Conciliation Agreement in Zedinga, and Home of Virginia. Those are key standards for that. What recommendations can we offer based on this? We had the hypothetical applicant, 15-year-old black male, 15-year-old conviction for felonious assault or also felony, served 15 months, has not had any criminal record since that time, and he meets the income, rental history, and credit requirements. What decision would be, or what other factors would you like to consider? All the factors listed above, the length of time, circumstances, what he's done since release, and so forth. And looking at those factors, if he served 15 months in a state prison and got out 3 months ago, maybe you wouldn't, right? Rent. But if a number of years has passed, HUD says 3 years is sufficient. You may even go a year and a half, 2 years, depending on the the conviction and if they're working and really turn their life around, maybe just fine. But the fact of the matter is not relying on a blanket policy, but doing a applicant by application consideration. So what are some specific recommendations? First off, periodically check for state or local legislation for criminal record requirements. Michigan has pending legislation. Many cities do as well. But regardless of what requirements are enacted at the state or local level, the housing provider must still meet federal Fair Housing Act standards. We saw that with Detroit. Detroit is now under current Fair Housing Act standards and case law, probably overly strict. So you could meet the Detroit ordinance. You could turn somebody down for a 43-year-old felonious assault case, but you would be in violation of Fair Housing Act standards. Still want to check. Make sure you've checked for any state and local legislation, factor that in coming up with your policy. The requirements for public housing can be used as a guide for determining your policy for use in private housing. That seems pretty clear. And then the snapback would be what? How can you say we have a bad standard if that's what's being used in public housing, right? When in public housing, it's HUD approved. So it should be fine when it comes to private housing. If you draft your own policy without using samples such as listed above, you should be aware that if your policy is found to be overbroad, it probably will result in a disparate impact on protected groups, Black and or Hispanic. Then you will need to show that you have quote unquote empirically verified the effect of your policy. And I'm not sure a lot of people empirically verify their policies. They just adopt them and run with them. But if you do, and it ends up being restrictive, you have better have done that homework. So the best approach is to have a policy that lines up with other policies that have been approved. Carefully consider look-back periods. I thought I put it in the sample policy. I'm going to double check it. I mean, when I read it, I kind of looked over it. If not, I'll edit it. I'll put a 3-year look-back period in the proposed criminal record policy, but that's something for you to consider how far back you go. Again, it's not adopted by HUD with the 3-year, right? It's recommended. Whether HUD sticks with that or not, I don't know. We do know in 2001, HUD had 5-year look-back period. That's shaky. 5 years would be shaky. That's kind of long. So something between less than 5 and 3 would probably be in the more safe route. 3, I think, would be the most safe that you would do. Again, depending on whether there's some requirement at the local level or state level to require you even to have a shorter look back period. It's up to you. You can be more inclusive, totally up to you, right? But you don't want to be overly restrictive. That's where the fair housing violations will occur. You can exclude persons with conviction for manufacturing and distribution of a controlled substance or lifetime registered sex offender. And you should have a written policy also for termination of occupancy based on criminal activity. You want to consider opportunity for an applicant to consider mitigating information and list what types of mitigating information can be provided. You want to provide notice to applicants as to your criminal record policy. Please do so. You're not what's to hide, right? You want to do that policy. Keep all criminal records and other information concerning applicants or tenants confidential. That should be self-explanatory. Certainly on disability cases, all of that information has to be kept confidential. Also, you want to maintain records listing the reasons for denying someone occupancy or the grounds or factors that you looked at, and explain how you reached the decision to terminate occupancy for criminal history or conduct, as well as make sure you include how you considered any mitigating information that was provided by the applicant or tenant. Be alert to other types of discriminatory policies. Alcoholics and former, not current drug users qualify as persons with disability or restrictive policies, or policies that don't take into consideration medical treatment and therapy can constitute discrimination based on disability. And we mentioned about alcoholics, former drug users may need reasonable accommodations as to their low credit scores, prior rental histories, and so forth. Even some could really be raised as to their criminal record policies, because it goes with drug addiction. There's going to be probably some convictions for possession and so forth. So to make sure that since they do qualify as person with disability, they would have a right to a reasonable accommodation as to policies that would otherwise apply.